I have been able to meet the child only for 4 times. That too, the intervention by this Hon'ble Court. And we all argued the matter before the court. The court did not make any observation. Court did not do anything. Therefore, I can continue. Like this, they were even trial court also, and the threat. This is a kind of thing, litigation. This cannot go on like this, my lord. This is a message somewhere that is to be got. You cannot take it. One person cannot take this kind of litigation for their whims and fancies and make use of. The moment they find that the court is not in certain things are came on record. Now, at the convenience, they cannot withdraw the petition, just walk out of the situation. This is my response.
As well as in the memo of withdrawal in both places, I have told my lordship that the petitioner is a firm believer in joint parenting and the principles associated with joint parenting, my lordship. My only issue with the entire order, my lordship may peruse page number 91 of the objections filed by the respondent, my lordship. Page number 91, my lordship. Which is the letter, my lordship, where he creates a certain issue in the child's school, my lordship. That is my only issue, my lordship.
Please come to your petition. I'm looking at your petition. Then
My petition, my lordship, page number 6, my lordship.
The petitioner states that after the aforesaid interaction, the minor son of the petitioner and respondent is disturbed, and the same is taking toll on the child's education and extracurricular activities. The petitioner is distressed to see her minor son visually disturbed, and therefore intends to withdraw the present petition out of concern for her minor son.
That is right, my lordship.
Yes.
That's about it, my lordship.
My lord, the statement of objection which I filed it for a moment, lordship may kindly see the para number 9. Oh, sorry, para number 5, my lord. 6/4/2021. There is order passed by the trial court, family court, giving a visitation with certain terms and conditions, which he doesn't comply. And lordship may kindly see even court direct by order, orally, the direct by order, with order on 30th/6/2022, 23/9/2022, and 28/9/2022. All these days, specific direction by the Honorable Court to produce a child before this Honorable Court. They doesn't do that. And there was an opportunity, 6 times opportunity was them to file an objection statement of objection. That also they don't do it. Thereafter, lordship may kindly see this present impugned order was passed. That is on 2/6/2023. Now, lordship may kindly see this here immediately from 3/7/2023 till today. I have been able to meet the child only for 4 times. That too, the intervention by this Honorable Court. And lordship may kindly see there are two incidents they are talking about. One incident, lordship may kindly see talking about an incident happened in the school. He went to the school, being a father, he went to the school. He asked about the child's welfare.
No, that when
Yes.
I've interacted with them, I know what has happened.
So,
and
given a letter also that.
No, even the boy said, like, if he comes to the school and says sorry to the
I have
teacher,
no.
he has no objection. And that day was okay.
Please, madam. Second incident, lordship may kindly see there was a specific direction by the Honorable Trial Court in respect to visitation was picking up the child from the residence of the petitioner. He, contrary to that, she asked him to come to the hospital where she's a doctor. She's her own clinic where she's a dentist. She is a clinic where she's purposely created because circumstances wherein which it is as if it is some commotion and child is going to take away by forcefully and other thing. Obviously, child will get offended or something. This is only 2 incidents where happened. Lordship may kindly say, otherwise the child was during the COVID. Child was with my exclusive custody because during the child period I was taking care of the child. Thereafter, she took the child, came back to Bangalore. Immediately she filed disciplinary. That is how the thing. Otherwise, there are absolutely it is also not in dispute. They also admit that we had a good relationship with the child. Absolutely. Thereafter, lordship may kindly say during interaction also would have noticed the child was brainwashed to such an extent, stating that this is as if he is a monster kind of thing. The picture that has been painted and that has been day in and day out tutored to them. She is just using the child as a tool for her matrimonial dispute, nothing more, nothing less. Now, lordship may all this exercise past 21 onwards, child has been denied the right as a thing. So now they filed a petition almost more than a year. They kept this matter pending. All of a sudden, drop of a hat, they just file a petition and withdrawing it. This is nothing but a abuse of process. It's a classic example of abuse of process. A litigant cannot take the scrupulous manner to take the law into their hands. There should be, these are the cases, classic example should be send a message to society. That is my number one, respect of. Lordship may kindly see child at this point of time requires some sort of counseling is required. He cannot just withdraw and go back to the court and make an allegation saying that he went to the court, we all argued the matter, court did not any pass an order, now we are coming back, I will do whatever I want to do. This is the attitude. Normally it has been case in classic examples we have seen in other cases where they take advantage of this situation. Court, we all argued the matter before the court, the court did not make any observation, court did not do anything, therefore I can continue. Like this, they were even trial court also, and the threat, this is a kind of thing, litigation. This cannot go on like this, my lord. This is a message somewhere that is to be got. You cannot take it. One person cannot take this kind of litigation for their whims and fancies and make use of. The moment they find that the court is not in, certain things are came on record, now at the convenient, they cannot withdraw the petition, just walk out of the situation. This is my respect. This is a classic example. There should be, if at all this honorable court is allowing in withdrawing the petition with the exemplary cause, there should be message sent to the society. This is not a day in and day out. This process is happening. There should be some message to be sent to the society in terms of this is example. So far as my rights is concerned, Lordship, again, some certain direction may be given to the trial court for my visitation to be continued. That whatever the things happen to be restored at this point of time. If it is this is damage is permanently, there are some damages will happen. Let the child be sent for some counseling, or it has to be examined by the doctors at this point of time, because what is gone inside the...
In these kind of cases, counseling will not work because he'll be with the counselor for half an hour, 1 hour. The remaining time is with the mother. So how does it work?
There should be some solution, my lord. This is not the case which is happening, because there's a series of cases. The intervention of this court should be there in this type of matters. That is my respect to submission. Some guidelines should be laid on this type of matters. They should not be allowed this type, because child should not be taken for a person's personal litigation. This is a classic example. There should be some laws to be laid on this type of situation, my lord. Lordship, the records clearly shows that their own cases that child was in. What is the difficulty? Just because a father goes to the college, means to the school, and make a submission, that too my instruction is that child itself was not there. And they to pick up some isolated situation, if at all for an argument's sake, let me admit that it has happened. That cannot be a reason for denying a child's rights, a father's visitation. These are all constructive. What type of societies we are building up and throwing out? What happened to the child's mind tomorrow? So that is the reason why, even though so many visitation rights were granted to me, I could not exercise, because I just laid back, because I don't want the child to suffer. And that should not be an advantage for them to take it forward further. That is my respectful submission. So rest of the thing I leave to your lordship for appropriate order, my lord.
What are your submissions?
My lordship, there is no stay on the impugned order from the very beginning, from 2018 till now.
What is the confidence of the mother that even there is no stay, still he can, anyhow, the boy is
They
not...
can visit, my lordship. They've been in communication by email throughout. From 2018 till now, they are in communication through email. In fact, there are lengthy, voluminous emails by exchange between the parties, my lordship. There is no stay in proceeding for the last several months itself, my lordship.
No, ultimately, how many times the father could see the child?
My lordship, on every Sunday, my lordship. On every Sunday, the father is permitted to spend time with the child.
Permitted, but what was it happening?
My lordship, he needs to drop in a mail and come and pick up the child. They have been doing it all throughout from 2018 till now. Nothing has stopped him from doing it now. My lordship, also the other submission I need to make, my lordship, is that from the initiation of the proceedings before the DV court till now, my lordship, he has not paid a rupee of the arrears, my lordship. And also at least a child's fee, my lordship. My lordship, whenever he wants to...
So had your client been more fair in the system, in all this process, the court right now will also direct him to pay the school fee. But the fairness of your client, the court is not able to see.
My lordship, after the intervention of this court, I have also advised my client to permit the visitation, because there is no stay by this honorable court.
One thing is, I'll tell you, in one interaction, the boy had specifically stated about this, what has happened in the school. Then I said, can he come to the school and say sorry to the teacher? He said, yes. Then he said, no, the holidays, after holidays you came. Then when I see the boy, again after he spoke with him also. Then after that vacation or whatever that, after 1 or 2 months, when he came back, where this court has permitted him to leave to his, is it the case that her grandparents' place?
Please, ma'am, please, ma'am.
They went to the grandparents' place in Kerala and came back, my
Yeah,
lordship.
then this court has permitted him to go and come back. And after that, when the court meets him again, he was little, there was difference. Then after that, he is completely how a boy can be brave. And that is something which this court can't just let it like that. It is it's a case of complete parental alienation. He is all referring to what has happened when he was 2 years old. 2 years old, and he shouts at the father, and he never calls the father by name. He calls the father Sarath. He doesn't take he takes his name. Don't even call him daddy or whatever they call that. And how can she take advantage because the boy is with her? And this is not the way. And you can't make the other party so helpless.
My lordship has made these said observations, my lordship. I have also instructed my client never to do this, my lordship. And
That tell her she will. I'll just pass over this. There are two things. Either it is that she'll come she'll come fairly to the court, or else this is a case where the court has to observe that it's a parental alienation and the custody has to be shifted to the father.
my lordship, from the date of the order, impugned order, my lordship, we have been abiding by the order till the date of that incident, which they call isolated, my lordship.
Abiding. What is that abiding? The boy doesn't even speak to him. And when the boy is shouting at the father, which is not supposed to be, and if she is really a dutiful mother and who feels that her duty is to the discipline him or whatever to take care of his life, she would not have let him to speak like that to the father. In fact, she was encouraging it and also saying that but the father should be sent out because the boy is not he's shouting at him.
I concede to the submission of my learned friend where he says a counselor may be used to intervene and, set things right between the parents, my
Your
lordship.
client is a big counselor. No counselor can do anything to the client. Tell her, definitely in this case, though it is not, this court has never done, but it's a case where the custody has to be shifted. If she feels that she can just happily come to the court, seek a matter to be pending before the court for a year, and when the court feels that what she is not doing right, now she wants to withdraw the petition, no. But it could be like in any other property matter, in any other thing. Not in the case of this children, where this court exercises a parent patriarch jurisdiction, court will pass appropriate orders. Tell her that. I'll pass over this. Only after the matter comes at 2:15, only two things. Whether she wants to be filed to the court, and even about the maintenance and all other things also, court will pass an order. Or if the manner in which she wants to go ahead, then we'll pass an order.
My lordship may give a date where I'll have the party present before this court, my lordship, because it's an extensive instruction to avail as well, my lordship.
Don't have to interact. with her.
After
She's
the,
an educated woman.
That
She
is right,
knows
my lordship.
everything.
that is right, my
And she
lordship.
thinks that she can, just like that, she just go away with everything like this.
I have instructed my client on the last occasion very clearly, my lordship. For all custodial matters, I tell both the parents that there shall be no parental alienation before me, my lordship. That is what I have told.
It's a clear case of parental alienation.
I very clearly
And
told my client as well, my
that-
lordship.
Because there are proceedings on every date of interaction, this court has recorded. In all the interactions, how it has transferred, I have recorded it. So there is nothing that she can't even deny that. And now if she by this order, I'm telling you that I will pass an order, the changing the custody to the father.
My lordship, my only submission, my lordship, is that the impugned order that is there is now reverted back. There is no stay on it. The father may exercise his.
Court, I understand.
father may exercise
Maybe
his
you're trying to
visitation.
tell the court that the scope of the writ petition.
No, I'm not, my lordship. I'm only telling my lordship that for the welfare of the child.
Even if this matter, if this is withdrawn, it goes to the trial court, again another several years it will take. By the time this boy will turn into something else. He will even say one day that who is this Sarath, I don't know.
The father already has visitation. Let him exercise it is what my submission is, my lordship.
That's the whole thing. It's
No,
not
my lordship, it has been happening from 2018 to 2023, my lordship. It is one incident that has
If
changed it.
that stay incident can't be a reason for the mother because that's how she is treating him. And it requires to be changed. And he needs to know that he has a father and father also loves him.
My lordship make the necessary observations and allow the petition to be withdrawn is my submission, my lordship, in the interest of the child, for the welfare of the child, my
Get
lordship.
instructions from your client and tell her that this is going to be the order. I'm very much like whenever when I last met them in the chamber, I felt very bad. This is the way how a mother leaves a son to behave with the father. And how is she taking care of him? Is she really like going to be a good human being with her, with her, brought up and all? At least she's not even stopped him. On the top of his voice, he shouted. He was saying that when he was 2 years old, or you did this to my mother, you did. How will she remember what has happened at 2 years age? So he's completely tutored by the whole family, not only the mother, along with the others also. So then now she was telling all about the Bhagavad Gita, all about the things like, I am not this child. Let her now understand how Bhagavad Gita works and how the sermons works.
I may seek instructions from my client, my lordship.
Please
A
seek
date may be
advice.
given, my lordship, because she'll also be in clinic. A date may be granted. I shall seek instructions from my client, my lordship.
Now we'll do one thing. Now we'll post this matter by this weekend. This is also one more, like the court is giving her a very long rope. Now we'll post this matter on Monday. This weekend, the interaction and the visitation should go on.